Sorry, guys. So, like Lynn said, I've been with Frontier Title over 10 years now, but I've actually been in the business over 21 years. All title. I've done every aspect on the title side, um, title department examination, external citizen, escrow officer. So I'm hoping I have a wealth of knowledge for you guys. I'm really learning something almost weekly. Been into this 21 years. Yesterday, I was like, oh yeah, that aha moment that I'm going to be new about POKs. And that's for another class, another time. And it's just crazy because things are always changing. So you just make sure that you guys are always up to speed with the information because laws change, regulations change. Um, Case in point, marital status rights. A lot of stuff has changed along the way, and it all basically was born out of our Texas Constitution, and I'm going to talk about that. I mean, it's a history of marital rights, community rights, separate property, and so forth and so forth. So I'm going to break down all that information for you guys. I always have questions from agents when they ask, does the spouse have to come in? Do they have to sign? So and so bought it, single, but do I have to bring in the wife? What questions do I ask the wife? What questions do I ask the husband? Here. Cool. So it really is going to start with you guys. You guys are the main point of contact. You guys have the listening appointments with your clients. We don't. We don't get to sit down with them right off the bat. I don't have a questionnaire to go over questions with them. You guys are there. You guys are at the front line. You need to ask the question. Have you been married? Have you been divorced? And somebody passed away? The key point is always from the date of inception, which is the date that they bought the property when they went into title forward. That's what we want to know. That's what you as an agent want to know. That's what title companies are going to ask for. What happened from the deed forward? Married, divorce, what happened? Is there a will? Is there no will? After marriage? That's what we want to know is what happened from the deed forward, and always starts with the realtor because again, you guys have the listing appointments, get all that question, write all that because when the title comes through, I'm going to turn around, I'm going to ask this. Um, so you guys can have paperwork with you. Those are just little checklists that we as a title company are going to ask for. And I just gave you a very default general checklist. It contains information that all title companies are going to want to know. Sellers are usually are oblivious to their own title problems. They don't know what's on title. Sometimes they have no idea what's. Oh, I didn't know I had this. I didn't know I had a judgment. I didn't know that my ex still has to sign off on the deed. And we've seen those situations where they've gotten divorced, but yet the spouse still have to join in because said divorce was not done correctly. And I'm going to talk to you about that as we go through this class. So sellers usually don't know what they have to do for their title. That's what title go still up. You guys know the agents are going to still up. Many people are from out of state, don't understand Texas is divorce and community property laws. Texas is a homestead state. Mine is yours, yours is mine. You can't just buy property and sell property if that property is your homestead without the spouse. I mean, to you a lot of time, but we get a lot of those questions. I just want to buy this property by myself. I don't want my spouse to join in. Does my spouse have to join in if I want to buy a home? Now we're going to cover that. Our Texas laws are different from a lot of other states. Main one being it's a community state, so we have homestead rights that we need to protect when it comes to spouses. Supreme Court ruling requiring all states to permit marriages between two people of the same sex and to recognize each other's form in other states does not affect closings in Texas. In other words, we don't care that you got married in Virginia and California. You can go by Texas rules and Texas laws when it comes to property in Texas. And again, we're going to talk about that. Recognizing problems can sometimes get you to sell or keep the sale from falling apart. I've seen it many times. Again, we're going to go in depth with that. But again, case in point, somebody bought the property seed, and now their spouse moves in. It's their primary residence. 10 years later, they want to sell. That seller, that original owner comes to us and says, I want to sell the house, but I don't want my spouse part of it. She's not entitled to the proceeds. I bought it. It was just my property. Well, not in Texas. If that's her primary residence, she's going to be involved. And we're going to talk about it. And I've seen deals fall apart because A didn't want B to join in. I bought it separate. It's my property. You should not be entitled to it. Well, maybe you're separate property, but homestead rights come into play. And we're going to talk about that. And like I said, there is a checklist that we go over on every single transaction. The one on the screen is just a default list. What you guys have in front of you is the actual ones that we use for every single transaction. And it's all the information we're eventually going to ask. Marital status, marital history, um, divorces, death. I think there's even POA language in there. It's really everything that we're going to ask right off the bat. I think it's also asking if they're a foreign national, if they're a U.S. citizen. So it's a good starting point with your listing if you have this ready to go with them. So you have them fill out all your listing information and your agreements. Throw this in the mix too, because this is what a title company should be asking for, because it's what I ask on every single transaction. Do you need a spouse to sign? So typical title commitment exception. We must determine the marital status of the record owner or owners prior to and at all times subsequent to the acquisition of subject property and require joinder or affidavit. Attorney language. Basically, I want to know what happened from the deed forward, and I'm going to make that determination of whether or not that spouse has to join in. This is why we have the checklist. This is why I want to know the marital history. But this is on every single title commitment where the seller is an individual. Now, if the seller is a company, an LLC, a corporation, a trust, I don't care about that. But if they're an individual, we need to address any spouses, current or past. Typically, the title company is going to deal with this exception with a marital status affidavit. So a spouse is always going to join in one way or another, whether they're going to join in the entire transaction and sign all the documents, the deed, the disclosures, everything, and be entitled to the proceeds, or if they're not, they can sign an affidavit. So the marital status affidavit is your marital status history. That's what I want to need right off the bat. Prior, current, what's going on? Person inside your house, is that your boyfriend? Is that your girlfriend? Is it common law? Because common law is also recognized. You're good, no worries. So, marital status affidavit is different from a non-homestead affidavit, and we're going to talk about what non-homestead affidavit is. But a marital status affidavit is going to be on every single transaction, just like that checklist. So just like that checklist that I give on every single transaction is also going to have a marital status affidavit. And it's just that, it's basic marital history information. Okay. Marital status affidavit is your history, and then I'm going to get into what a non-homestead affidavit is. This is when the spouse does not have to join in on the transaction. But every single title company, we want a marital status affidavit. We want the entire history of the marital status. If the spouse stepped out, can come and file the claim suit against us. The big time in Texas because we have homestead rights. And I'm going to just keep repeating that word throughout the class, because that's the key takeaway because of Texas, homestead rights. Your customer should be aware that if the affidavit is inaccurate, they may be voiding their title coverage and may be liable for the mortgage company's loss. In other words, if the seller lies on the marital status affidavit, single. No, they're not. Or they were currently married, or they were previously married after they bought the property and then got divorced, and they'll just let that out. And I've taught that at closing. We don't have a contract then because I don't have all the sellers accounted for. But we're going to have a massive delay because I need to figure out who that spouse was because you lied, and now I have to lend their name. Usually, when they try to keep the spouse's name on the record, is because the spouse has liens. Oh, it's their child's boy, so they're not part of it. They're an owner of the property, they have homestead rights, they're going to pay that at once. All liens for all spouses are going to be accounted for. I don't care if you bought it separately and then the wife joined in later on and she took out liens, all liens are going to be accounted for. So if they lie on the affidavit, it's going to be on their shoulders. Marital status, the marital status affidavit basically asks when the property was acquired, each marriage or subsequent divorce, and present marital status. So we give this to them during the transaction, and I also do it one last time at closing. Again, I just want to make sure, what is your marital status as of closing? I do have a sign-up sheet here for you, and then I have a checklist if you want a copy. And then just a copy of the checklist and then sign up as received. Okay, so just marital status affidavit is basic marital information. Do you need the spouse to sign? Now I'm going to go into Texas Constitution, attorney language, and I'm just going to break it down to you. So does the spouse need to sign? Article 16, Section 50 of the Texas Constitution provides you need both spouses' signatures. Sell a homestead. Now this is when the home is their primary residence. They don't have another home anywhere else in Texas. But if they don't have anywhere else to live in Texas, a home, I'm not talking about an apartment complex, a home, then this house is their homestead. Whether or not they file a homestead exemption application with the appraisal district so they can have a homestead, if you do not have a second home, the home that you're living at is your primary homestead. So I cannot sell my homestead without my spouse. That's her primary residence. That is her homestead rights. If I bought the property separately, I got married, she moved in, she lived there 10 years, she doesn't have another home. This is her homestead. And per the Constitution, I cannot sell the homestead or execute a deed without my spouse. I can also place a lien on the homestead, which is signing on the deed of trust. So this is like if a buyer wants to buy a homestead, they want to buy a home, but it's their primary. Okay, are you married? Yes, if your spouse has to join. Whether or not you like it, spouse has to join it. Because you're buying a primary homestead residence, that spouse is going to join. Now, if I'm buying investment property, if I'm buying land, obviously she can't live on the dirt, and she's not going to live in my commercial building because it's investment property, then okay. Different situation, she can sign one affidavit, not what it is. She doesn't have to join in the transaction. This is not her homestead. Right? I'm not buying a homestead property. Very, very big when that buyer is buying homestead property. Texas Family Code Section 5.1. Whether the homestead is separate property of either spouse or community property, neither spouse may sell, convey, or encumber the homestead without the joinder of the other spouse. Again, basically just reiterating what we just went through. Can't buy, can't sell without my spouse when it is a homestead. Now I'm going to break down what separate property is and what community property is. We're going to go through it. But in hindsight, separate property is something I want separate. Then I get married, they move home. Community property is I buy something while I'm married. That's community property. So like if you go through a divorce, they're going to look at what did you buy as community property? In other words, what did you buy during your marriage? They'll also look at what you bought separately. You more than likely you're going to be awarded your separate property because you bought it separately. But what did you buy as a community property while you were married? Because if you have questions, let me know. If you're confused on any of these topics, let me know. Do you need a spouse to sign? No, to realtors. If you don't have both spouses, sign your listing contract on homestead property. You may not have a valid listing contract. This is why I have agents that call me up now before they even have a contract. Hey, Ricky, does Jane Doe need to join in? He bought it, so forth, and then they got married, and now it's her homestead, and this is their only house. Yes, she's going to join. Okay, then they get the contract ready to go. Because if they left out the spouse, who is technically, they have homestead rights, you may not have a valid contract. So call me up if you're confused, if you're not sure, you have questions, you want to make sure you have a legit type contract. Do you need a spouse to sign? Answer, when it's homestead, we talked about it, always. When it's non-homestead, land, commercial, investment. Only if both the husband and the wife are entitled, obviously if they're both buying. If they're both buying it, then yes, obviously. If the spouse is not joining in, spouse will need to sign a non-homestead affidavit designating your homestead. This is what I talked about earlier. A non-homestead affidavit is basically a one-page document that says you are disclaiming this property as being sold, you have no interest in this property, and you live somewhere else. It's always going to have it's always going to state that statement. You live where? You got to give me that address. You got to be somewhere in Texas. Somewhere in another state, we may have a problem. You're not following the Texas Constitution rules. So non-homestead affidavit means the spouse does not have to join in the closing, but they're going to sign one document. Okay, you're good. You're not entitled to the proceeds. You don't have to come to closing. You sign this one document, you're good to go. Or the alternative is you join in and you sign it. And that's usually when they live in the property because they're primary use. So one or two ways. Like I said, the spouse is always involved. Going in or sign the non-homestead affidavit. Let's explain it how. There is homestead, there is community, and there is separate property. We're going to break down each one. What is homestead property? Very generally, either a residence with up to 10 acres in the city or up to 200 acres in the country. Title company will treat property as homestead unless the owners and the spouse have other real property in Texas, and I mentioned that before. I don't care about another state. You have another home in Texas that they will designate in writing as their homestead. Taking a homestead exemption on your property taxes is not inclusive as to the homestead status of the property. That last one confuses people because it talks about the homestead exemption, and people think, well, I filed the homestead exemption, and so obviously it's homestead. I married, me and my spouse, we bought the property, bought the house together, but only I filled out the homestead exemption application. Does that mean she doesn't have homestead rights? No, she still has her homestead rights. But my name is on the homestead exemption application. I'm not talking about the homestead rights. I'm just talking about the tax rate that I'm going to get on the property taxes. Sign up sheet for you ladies, and then we have copies of checklists for you. So again, just following the homestead exemption application doesn't mean that my wife immediately is covered. She's covered because of her primary residence. Okay, keep that in mind. And I always get that question too because they pull CAD, like you guys will pull CAD when you're pulling like the legal information and you're doing your listing appointment or your contract. Hey Rick, the CAD only shows John Doe, but it's Don and Jane Doe are both selling. Okay, that's fine. That doesn't mean Jane Doe is not part of the transaction. It's just showing John Doe. Either they ran out of information or ran out of space to add in all the information on top, or John Doe just bought the property by himself. So it's just showing his name. But you know she's living in the house. It's her primary residence. She's going to have to be part of the contract, regardless of her name is on the CAD or not. You know, because you're asking those questions, you have them on checklists. This is her primary residence. He is going to join in on the transaction. It's her homestead. Homestead property, same-sex spouse. Don't have to break it down. Again, I don't care what happened in Virginia, California. We treated Texas laws. You're going to follow just like opposite sex marriages. I don't care. They have the same right. We do. There is no difference. This was added into the class when the laws passed in Texas. It's basically just reiterating that everything is exactly the same. We treat nothing differently. Same-sex spouse of the seller of homestead property will be required to execute the deed regardless of the date or location of the marriage. As with opposite sex spouses, this applies regardless of whether the property is community or separate and regardless of whether or not the spouse resides in the Again, it's just the same information that we've been talking about. When an owner of the property dies, a surviving spouse retains homestead rights in the homestead of the deceased, even if that spouse did not inherit the property. Everybody understand that? Okay. When an owner of the property dies, surviving spouse retains homestead rights in the homestead of the deceased. That doesn't mean she automatically got interest in the Yeah, we still have to do affidavit of heirship, probated will. Are you actually the owner of the property? What we are talking about is she has her homestead rights covered. Okay. Example. Let's say I bought my house by myself. It's only me. I'm on the deed, just me. My wife is not on, okay, but she lives there. She's not on the deed. Her name's not on CAD, but she lives there. I die. The interest of the property doesn't automatically go to her. We still have to do affidavit of heirship or we do will. Her homestead right is protected. So let's say she's not the heir to it. Let's say I did have a probated will and I left her out and I gave it to my kids and they're the owner of the property. Her homestead right is still there. She has to join in. Her homestead right is protected. You can't get rid of her homestead. Again, go back to the Texas Constitution. Her homestead right is protected. That kind of makes a little bit more sense now. You can't just
So
take
they
her home.
can't sell it.
Can't sell it without her homestead. Basically, she's gonna join. She's gonna join. You can't just sell her house. If it's her primary residence in Texas, her homestead right is accounted for. She's not entitled to money. She's not entitled to compensation. If the kids want to give her something cool, she's not entitled to that. If she is not the owner of the
So
property.
then they have to give her notice so she can move out? Is
If
that
she
what
wants
they do?
to,
But she doesn't have to.
she has homestead rights. She can't get her out. Her
Okay.
homestead right is protected.
So how does the attorneys and probate will, all that stuff come into play to be able to move out?
You should. I don't have to slap on the deed. Her homestead right is protected. He has to join in on the transaction.
The sign.
The sign.
Okay.
She's not entitled to compensation,
Right. Okay.
but homestead right, she's protected.
So if she doesn't want to move out, they will need to wait until she dies.
Or buy her out.
Hmm.
I've had that come up before. They want to buy her out. I can't say yes, give her money. That's you guys.
Mhm.
But homestead right is protected. You can't just
So
say it up.
if she chooses not to move out, then you're telling me that the new owners that inherited the property cannot sell that home?
Yeah, her homestead right is protected.
So they cannot sell it.
But she has to join in. Homestead right is protected.
So then she stays there, right? So what legal recourse does the inherited have to be able to collect compensation on that house for living there?
Until after she dies?
So after she does, or
So you're telling me that somebody can die and they can stay there, and she doesn't have to pay a penny and live in that house, while the people that inherited the house have to make payments on that?
Yeah.
So that they won't lose it?
her homestead right is protected.
Really?
Homestead right is protected. You can't just kick out mom because
Correct.
she's inherited the property.
But there's no eviction notice that can be given?
No, I'm sorry.
Yeah.
That's gonna be over me.
That's
Something I should have been told for.
Right.
But if you want to talk pen and paper, black and white, what the Constitution is there to protect, is to protect your homestead. Good luck finding that in the form. Because that's the Constitution. That's for homestead right. And you can't just take it away from them. That's gonna be a fight. I had that. And
what's the outcome?
nothing you can do. It ain't close. It ain't looking at me. I don't know what they did, but it ain't easy to me. You can't just pull a rug from under her. It's her homestead right is protected. But again, it goes back to her not being entitled to compensation. The interest may not be hers. So if they can go to court and work out a deal and maybe give her something to put her hand on the pen.
Let me just give you a scenario. They inherit the house. She doesn't want to move out. They're like, hey, you know what? Just let her foreclose. What happens then to the homestead rights that she has?
Well, for foreclosure, then it forecloses. Then she's gonna be out of the house.
So then at that
And
point,
then-
she needs to move out.
And then,
No, I know, but at that point, it's like, hey, and I'm just
yeah.
worst case scenario, whatever, because you're telling me, hey, she
Yeah,
can.
that's not gay. In that case, that really uses property.
Because that's because of the bank or the lender.
Yeah.
Any taxes out there if they don't pay.
Well, yeah, I mean, they're foreclosed, it's theirs.
Right. Yeah. Wow.
Would the heirs be entitled to collect rent from
From her,
her?
I don't know if they could on that.
It's a legal question.
Yeah, it's a legal question because Constitution doesn't say that they are entitled to compensation or reimbursement. That'd be a legal question. I don't think so. That's just me, my personal opinion. That's not legal advice.
I've got a question. So you said if a person was not married when they purchased the house, but then 2 years later, a person, they live together, then they have that exemption. That homestead right. And they can stay there because that's now both their houses, correct? Okay. So when would it just be considered separate property? Is that when it's inherited to the husband?
And we'll talk about it, but
Okay.
yes, that's fine.
Okay.
But yeah, there's caveats of it being a gift or inheritance. But it'll come back to homes. It'll come back to homes. We're gonna talk about that.
And so that person doesn't have to be even married to the owner.
That's
It's
what
just someone residing
Let's
with
come.
common law.
Well, we'll talk about that too.
Okay.
You are going to talk about that?
I thought about that. Oh, yeah. You get in depth on that.
I'm asking, I guess, more or less like a rooming situation. Not necessarily, they're not like life partners, they're just rooming.
But the roommates, no.
They don't have the homestead exemption.
Well, they would because
Homestead rights?
So homestead, right, yeah,
What, are they just roommates? Like, I'm just living with my buddy,
yeah, like.
we're just roommates,
You're roommates, you let me to stay there,
not common law.
not common law.
Hey, but if you're roommates, then that's your homestead.
homestead.
Yeah,
Is that
If
for
you're
you?
roommates, but then you sign a lease agreement.
Then you must have to sign a lease agreement, right? That's your, that's your own person. Lease.
so you can be evicted because you're a tenant.
You're a tenant.
What if there isn't a lease?
But so I own my house, but I let my buddy move in.
Yeah,
We're not in a relationship,
Yeah.
and no, there's no homestead rights. We're not in a relationship
so it's only,
or common law.
okay, so it's only for spousal.
Only marriage and common law.
Got it.
And
So what's the definition of common law?
Sorry?
What's the definition of common law?
I get it.
Sorry,
I got it all. It's okay. It's in there.
Still-
It's gone.
Well, no, I want to keep it on topic, but really quick. What's the extent of you having approved as a homestead lady, right? You know, what proof do you show that, hey, I live here, this is my homestead?
Homestead affidavit.
Homestead affidavit just on her part.
Because it has into the information. If she's lying, in the city, that's on her. Everything is being tested. Marital status affidavit that was present at closing. If you lie to me about your marital history, you attested to that, and we find out that's on you. Everything always comes down to signing.
The affidavit.
So the homestead right is only specifically for the survival stuff.
For this writing stuff.
Okay.
Yeah, in this situation, but we all have homestead rights when we're married
Yeah,
and as a primary residence, but in this, yes, we're right.
that's so weird. I ran into a gentleman that went through that, and I was like, how did they kick him out? And he didn't get it. He literally told me the story, and I was just like, how did that happen? And so now it all makes sense. Wow, remember? Yeah.
Community asset property. Community property is all other property acquired during marriage. Remember I said that earlier. Community property is everything that me or that I bought. It doesn't have to be me and my wife, but I bought while I was married. While I was married. No, that's community property. Okay. I bought an investment property. That's community property. I bought it during marriage. So if I get divorced, that's going to come up as community property. Okay. All property owned by a married couple is presumed to be community property on divorce or death. You basically have to prove otherwise. How was title taken? With joint tenants? That means the death of one owner. The death of one owner means that owner's share automatically passes or goes to the other owner. When a tenant in common dies, their share is passed to their legal heirs. Everybody understand that? Because you can add this to a deed. I have a deed. I bought the property, and I bought it as husband and wife. I bought it with my wife, and we bought it as joint tenants. I die, it automatically goes to her. My 50% automatically goes to her. And I believe with this, I'll probably ask for like a death certificate only. Not the probate will and all that. Usually with underwriting approval, this is a lot quicker. So the deed is joint tenants, me and my wife. My 50% automatically goes, and it doesn't have to be my wife. It can be my brother. Me and my brother bought the property. We have it as joint tenants. I think there's also language that says like surviving tenant, something like that. But joint tenants, that means I died, automatically goes to him. Whereas a tenant in common, I die, it goes to my heirs. Not just my brother, even though he's my brother, it's my heir too, but it goes to my heirs. That's tenant in common when they die.
It was not specified in the deed.
If it's not specified, it's gonna be community, homestead rights, we're gonna treat it just like a general transaction. So if it just says me and my wife, husband and wife, can't break that, that's homestead rights, that's community property.
But it wouldn't be, I'm sorry, it wouldn't default to,
Community
Nancy
property.
Common.
If I bought the property while we're married, it's community property.
Right.
Yep. But if I add that language in there, joint tenants,
So it's specific to the language.
it's specific to the language. Same thing that you'll see on deed where it says John Doe sole and several property. It's specific to the language.
So let me ask you a question. So then if it's a tenant in common, then if the brother dies, everything's gonna go, inherited to the children. Do
It's
they,
theirs.
would they buy the brother out or,
Yeah,
okay,
it's in there. So I die, so me and my brother and Tato, I die, and the deed says tenant in common, so I die, it goes to my heirs.
Right.
And it could be my wife, I'm married, so my 50% automatically goes to my wife. Now my brother and my wife only, okay, he can buy her out, she can buy him. Separate property means owned before marriage, inherited, received by a gift, or divided by a written agreement. And, oh, it's not written, separate property is everything before marriage, or inherited gift. And you guys need to slow down the slide, let me know.
I've got a
And
question,
that's the second home.
or primary,
It could be a second home. Like if I bought it separately,
Correct.
it should be a second home.
Well, I mean, and it becomes a homestead when you let your spouse move in. And so,
Primary now. All right, Texas community property state, as you don't know by now. Community property is any property acquired during marriage and not deemed to be separate property. We talked about that earlier. The requirement that both spouses must sign documents may be waived if title to the property in question is vested solely in one spouse, and both spouses execute an affidavit, we talked about that in the homestead affidavit, which they designate the other property as the homestead, disclaim any homestead interest in the property in question, and acknowledge that the property in question is subject to the sole management and control of the signing spouse. That's what the non-homestead affidavit is. The spouse comes, he signs that affidavit. I don't live in 123 Street that's being sold. I do not have interest in it. My spouse owns it. It's his interest. I live here. That's on the affidavit.
I have a question. So how does one protect himself, like saying, hey, I've got my girlfriend, she's gonna move in, it's gonna be preliminary. How does one protect himself? Does she have to sign a prenup of sorts? I mean, they're not married, but
Prenups are not recognized by title companies.
they're not? Okay.
So you
So,
can have an agreement of sorts in place.
mhm,
I wouldn't put it in part of a prenup agreement, but you can have an agreement of sorts when it comes to the property. But
mhm,
she doesn't have any other property in Texas.
correct,
This is her primary residence.
correct.
If you present yourself, and again, we're going to go into it. If you present yourself, as husband and wife, or if you present yourself as husband and wife in the future,
Mhm,
the common
correct.
homestead right protect.
Automatically that takes over. That's precedence.
She doesn't have any other property, no primary residence, and you are conducting yourself in plain house.
I ran into this not too long ago too, and so like we didn't pursue it, they didn't sell, whatever happened. But it was a little different because he was moving out, but it was his house. And so I mean I didn't get the listing, but I'm just trying to remember, I was like, how is it that he never stayed? And he ended up moving out and not being able to sell because again, he didn't want to leave it without a house and stuff like that and whatever they were arguing. But it does happen, and it's happened to me before, and I was like,
I don't think a lot of people know about that.
Oh,
No.
yeah, it's very tricky.
Yeah.
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 And I'm gonna go in depth when it comes to that comment. I always get that question too. Well, where's boyfriend, girlfriend? And wait, so my boyfriend is gonna be in his house above the level. It depends. So we're gonna talk about that too. Like, what are you doing? What act are you putting on? Are you acting like husband and wife in plain house? You shouldn't be doing.
Did you go over the definition of common law? Because I have,
Not yet.
no, okay,
No, no, it's coming up.
okay, thank you.
Of course. Community estate is dissolved upon death of divorce. So community estate is gone when you get a divorce or done. Separate property is property owned or claimed before marriage by a spouse or acquired after marriage by a gift, advised, or assent, including recovery for personal injuries, except recovery for loss of claim capacity. Basically, it was gifted, it was awarded, as a judgment, a court order, they were awarded property. That is not community, that is separate property to that person who the property was awarded to. Non-homestead property may be conveyed by the owning spouse without the joinder of the other spouse. We talk about that. Commercial property, land only, investment property, yes, they can sign without the joinder of the other spouse. Is it considered non-homestead?
Great question. So they've inherited and it's a separate property, but then, say that the house was given to the children and they're 30 years old. And they move somebody in with them to live. Then that homestead wouldn't apply to them because they had gotten that out of the inheritance, correct?
Out of the gift
Okay.
of inheritance. If separate property is maintained or improved, this is what a lot of agents and a lot of owners don't realize. If separate property is maintained or improved with community funds, the property remains separate, but the community estate may be entitled to reimbursement. The joinder of the spouse is not required for conveyance or encumbrance unless the property is homestead, but the title company may want the spouse to disclaim an interest in the proceeds from the sale. The right to reimbursement becomes important upon the death of the spouse or upon divorce. What that means is I bought the property separate. It's my separate property. It's an investment property. I'm married. I have my homestead with my wife somewhere else. This is my investment property. But my wife and I are using our money to put money into the investment property, rental, whatever. We're using our bank account, our money for this investment property that is my separate. Then I get divorced. She's entitled to reimbursement for the money she put in. Okay, and I see that a lot. And it's usually a laundry list of everything that they've helped. If it's a divorce, they want the last penny. So keep that in mind. When you're using community money to pay for separate property, and you get a divorce, they can get reimbursed. Community and separate property, conception of title doctrine. We determine whether property is separate property or community property based on what the status was when the property was acquired. You bought it single, you bought it married. Right of reimbursement. Talked about that. The community funds are expended for the care and maintenance or upkeep of separate property or payment on a mortgage. I see that often. That can create a right of reimbursement to the community estate upon the title.
What about physical labor? So parental situation, right? So, the spouse ended up coming in and help repeat that investment.
Okay.
So they didn't necessarily invest money, right, to get a painter, but they physically put that investment property.
You'd have to show proof. So during divorce, they usually will go like an inventory of everything that's owed to whom. And I don't think you can come on and just say, well, I painted. Where's the receipt? To that extent. Because it could easily be refuted by the opposing party, the husband or wife. I would say you're probably not going to get reimbursed because, like, how are you paid for that? There's no way to comp that. How do I compare that with something else? There would have to be receipts or a paper trail or something like that. Not just your time.
I've got a question.
That's different.
So, say, when did the laws change from separate to community? When you started having like a common law? Because I know I had a friend of mine, and this was years back, but she sold her property, and then in her second marriage, they took the money from her property and did all the upgrades to their property. 10 years later, they end up going through a divorce, and he kept the property.
So you're saying like
She wasn't able
why
to.
would, but was she reimbursed though? Is that where you're?
Yeah, like I don't think so. I don't think she ever got reimbursed for selling her house and then putting everything into.
Sure.
Yeah.
I mean, I don't know the exact date of when it's.
But I'm just wondering, was it because the laws changed from
I don't
separate?
remember that being
To
changed
community?
anytime soon.
Maybe she didn't speak up about the fact
Yeah.
that she paid.
Or she
Or
didn't
her
know.
attorney?
Like I said right now, not a lot of people know that. What's
Yeah.
reimbursement?
Um,
Agents don't know that. Owners don't know that
right,
until you're educated. So they may have done not known.
it's
Which
like,
you
well,
would've been
they owned
entitled.
it beforehand, so they have to
Sell their money.
And yeah, I absolutely would have want my reimbursement.
Yeah, the equity that she took
Oh
on.
yeah, absolutely, she would have been reimbursed.
Yeah.
And we collected when they closed. So in the divorce, let's say she did do that and she showed receipts and okay, you're owed 50,000. Obviously he probably doesn't have the money to do it, but come time for you to ever refinance or sell that property, that title company is gonna take that 50,000 away from that. So eventually she would have gotten paid.
Wow.
But yeah. Tracing, because all property is presumed to be community property, you must be able to trace property back to when it was separate property in order for it to be treated as separate property. In other words, in our eyes, it's all community until we can go back in the timeline and go back through the deeds and see where it was just single property. That's tracing. We're basically detective work to see when it was separate property. With real property, this is fairly easy because, and I just said it, records, mortgage payments, amortization records. We can basically pull up the deeds. They already, already. We can basically pull up the deeds and create that chain and go back and see when it was separate property. So fairly easy when it comes to real property. Community, when you mix separate property with community property to the point where you cannot trace it, it all becomes community. In our eyes, it's all community property if you cannot prove otherwise. Okay. Whether property is community or separate property is determined at the inception of title. Again, that's when the title was taken, when it was purchased. If a person who is married to a same-sex partner in another state purchases property in Texas, it will be community property of both spouses if the purchase took place on or after June 26, 2015, when legislation changed Texas. If that purchase took place prior to June 26, 2015, whether it is community or separate property is not completely clear at this point. Because that's when Texas recognized. That date is when we recognized.
And it's only for same-sex partners.
When out of state, yeah. So they wanted them. Yeah.
Yeah.
They're out of
Like a
state.
specific scenario.
Texas is different. Yeah, intestate.
So why 2015?
That's when legislation changed. That's when it was same sex was recognized in Texas. So going forward, it's all community property.
Let's say that it's just a normal deal, and let's say she bought the house on her own before getting married, and all of a sudden she got married to this guy, and then they bought a house together. Does he have any right to her house, even though they never occupied it?
For separate property, does he have right to the separate property? So they own two houses.
Yes.
One is the primary and the original one that she had.
It's hers. Does he have any rights? Well, is there any possible way that his kids, in the event that he passes on, can come in and say, well, it's part of the entire.
See, we should have been in our class from the beginning.
Right?
Now, if they bought it together, it's community property.
Yes.
During the marriage.
Yes.
Now, if she bought it separately, it's her separate property because he has a primary residence with him. Okay. He's only reimbursed for any money that he's used to upkeep the separate property. Okay. He paid money to the mortgage, he helped her out. They used the joint bank account to upkeep this separate property. If they got divorced, he's entitled to reimbursement for that. Now, death, his heirs are not entitled to that separate property. They're entitled to that.
That's exactly what I told her. But I get advisory. If you want to protect the asset, you might want to set up a trust and throw it in there, transfer it there, and be done with it. So that way he doesn't have that we have to worry about.
But it being the second house and she had a primary with him, then that's really good because this cannot no longer be for homestead, for joint homestead. So as long as you had two houses in Texas, then she's good. And now it's separate property was bought separately. They didn't use any money for upkeep.
Yeah, but it is that it gets scary because when people die, all of a sudden they were nice to you. The moment somebody dies,
Oh yeah. Money.
wow, money
changes.
Yeah, money changes people, and all of a sudden, she's dealing with a ex-wife that even though they haven't been married, they divorced over 20 years. He's still paying alimony to her, but because she got the right attorney for sure. So she didn't want to have problems. Forget about him, her.
Yeah.
Because she really is after the money. So yes.
All right. And death intestate. Intestate means no will or the will was not offered for probate. So if you ever hear the word intestate, they died intestate, that's what it means. No will or the will was not offered for probate. When the decedent does not leave a will or the will is not offered for probate, it is necessary to determine who inherited the will. This is done by acquiring complete information about the tenets of the life the decedent needed to determine the heirs at law, mainly marriages and children. These facts must be obtained from someone with direct knowledge, willing to swear to the accuracy of the facts, and who will not benefit from the results. This is all attorney language. I'm just gonna break it down, affidavit of heirship. Okay, that's what it means. That's what we need to do. And when it says, we need somebody who had direct knowledge of the person passed away, these are the two witnesses on the affidavit of heirship. If you've ever done one before, if you've ever worked a deal or known an affidavit of heirship, there's always two witnesses involved. These two witnesses need to have known the deceased for at least 10 years or more, every single time. You cannot use, and it probably talks about it, and now I'm jumping ahead, you cannot use direct family members. Like I died, the witness for my affidavit of heirship cannot be my brother, cannot be my sister. Why? Because they may be entitled to interest, but the conflict of interest. So it's got to be extended family members, a cousin, maybe a grandparent, extended, but we always say use coworkers, use friends, use neighbors. Stay away from family members because you can delay closing if all you have are family members or witnesses, because underwriters do not like that. It's conflict of interest because they may be entitled to the interest of the property. Okay. Will is only valid if it's probated. And no, you cannot probate it while you're alive. Okay. I've had people call me up, hey, can I probate my will? I said, I gotta wait for you to know. You gotta be dead to probate. Okay. That's what certificate's true. We do the affidavit of heirship. So that's where it's talking a big paragraph, big attorney language. It's affidavit of heirship. All heirs must sign a deed and other seller documents. Seller, because they're technically right now are sellers. The affidavit of heirship is determining who are the rightful heirs, and if we determine they're the sellers, then they are the ones that are going to sign all the documents that are going to be entitled to the interest and all the good stuff. We have to sign everything. I've had the most sellers I've ever dealt with, I think, was 17 sellers. And that's because nobody had a freaking will. Please get a will and get it, make sure it's probated, but it wasn't probated. So when you have an heir because of an affidavit of heirship, and that heir is dead, then it goes to the next heir, and the next heir, and the next heir, and the next heir, and it just keeps going until we run out of heirs or until we hit a probated will. Okay, so in my case, it was 17 sellers. My manager, my former manager, many years ago, she had 50 sellers. And it was because that no will, affidavit of heirship. A normal deed, we charge $200. That's just the standard deed that our attorney, and all real estate attorneys will charge between $150 to $200. This deed cost him $1,500. This for the deed, and he wanted it paid upfront. You don't want to give him a copy of that deed. You want to pay upfront. So many pages, 49 pages added to them, because they each get their own signature block. Signature page. Two witnesses who knew the deceased for 10 years or more and does not have an interest in the property. I covered that. Stay away from direct family members. If that's all you're left with, please use extended family members who knew the deceased 10 years or more.
Ricky, have you gone over Lady Bird deeds already?
I have not. This one, not going to take one because it does not. It's not a death class. I can though. I can talk about Todd and I can talk about Lady Bird. Okay. Todd, if you ever heard of Todd deed, TODD, transfer on death deed. It's awesome. You guys know what a transfer on deed is? Okay. Most of y'all don't know what Todd. Okay. That's okay. Because I want to explain. So let's see, I own property. Let's say I'm single. Obviously, my wife is not entitled to homestead rights. I'm single. I have my property, my house, and I sign a deed over to my brother. I signed a transfer on death deed over to my brother, to the Todd deed. He gets recorded with the county. It's not even recorded with the county. Okay? Done. I'm alive. He's alive. The deed's been recorded. The property is not his. The property is his the moment I'm dead. Now it's his. The deed already recorded. If I get a transaction that I've had before, and it's a Todd situation where the owner is selling it and he got to a Todd deed, I don't need a will. I don't need an heirship. I just need a death. It's awesome. Saves so much time and saves so much money. Lady Bird deed. This is a rare document, rare deed. It is out there. I've had a handful. I've been doing this as an escrow officer for 12 years. I've been in the business 21 years and 12 years, a handful of times. A Lady Bird deed is I deed my interest to my brother And he can go and he can sell. He's owner of the property. But I retain an interest in the property. I retain a right to the property. He can go and he can sell it if he wants to, but I have to join it.
Then you have to what?
I have to join it.
Okay.
Basically, think of it as like 50.
Mhm.
Unless I'm dead. Now the property is his. That's a ladybird. I retain a life interest. I think that's what it says over here.
I do.
A life interest. You can go, you can do whatever you want. It's your property. You can live in there. You're the owner. You pay the taxes. It's yours. But you can't sell it without. They can't sell the property without. While I'm alive. I'm dead. Yours. Move forward. That's
So on the transfer of on deed,
Uh-huh.
who's responsible for paying like property taxes? The owner or
Well, remember, if I did a Todd to him, he's not the owner. I'm still alive. I'm the owner. I'm
Once you die.
Once I die, then it's his immediately. I'm still the owner. It's kind of just setting it up. It's getting it ready. That's what I'm doing. And Todd is getting it ready for that date that I pass away. If I'm just getting it ready, then that means he's not the owner. He shouldn't be paying taxes on the mortgage. I'm still the owner. I'm just going to make it easy when I pass away for my roof.
But on the ladybird deed, you would have two people sign. Okay.
And I retain a life interest in it.
Okay.
And that's pretty much to avoid drama with the family as well.
Yes. That's what I'm saying. It's so easy.
Yeah.
Not a lot of people know.
So, okay, so the ladybird, I'm good with that. I actually have the one for Sydney. But, on the ladybird, okay, so I own a property.
Mhm.
And I can have someone join into the ownership?
Well, if you do the ladybird to them,
Yeah,
so if you do a ladybird to them, they're the owners. They can do what they want with it.
okay.
They can't sell it. You have a life interest in it.
So basically, I'm no longer the owner,
Correct.
but I.
You're really, well, quotations. You're not really the owner
Uh-huh,
because you deeded it to them.
okay,
They can maintain it. They can live in there. They pay the taxes. They can do whatever they want.
okay,
They can't sell
She has a life
it
interest.
without you because you have a life interest in it.
okay.
Now you die,
So I transferred the ownership, but I have the
you
insurance,
have a life interest in it.
okay.
And you can live in the property if you want because you have a life interest. You just can't do anything with the property like transfer,
Okay, question.
sell it, refinance.
Question. So if there's a ladybird deed and it's given to our sons, but they're married, wouldn't their spouses now have interest in that property?
Homestead rights. It's not a gift. You didn't inherit it,
Yeah,
but they have homestead.
they have to.
All it goes back to the homestead.
So in that case, the best one would be the top.
Top. All day long, I would. Well, top.
so the only like real reason like to do the ladybird deed would be like to not have like being responsible for the property, keeping up the property, and you are already giving them.
You're basically handing it over to somebody, but you can't get rid of it without me. So,
But
the
you
owner,
take care of everything.
upkeep, mortgage payments, taxes, you're the owner, but I retain the life estate too, life interest.
Okay.
So you get rid of it, I'm involved.
So then the best thing would be a trust.
That's for trusts.
Be other than instead of the ladybird or the dock.
Instead of a trust,
Uh-huh.
yeah, you can still do that too. You're talking about putting the property in the trust?
Yeah, for the sons or for your daughters.
Yeah, absolutely. When you don't need a style signature, now we talked about it earlier.
Ricky, thank you for your time. Thank you so much for what you guys do and for your support through all of 2021. You guys were just absolutely awesome. We really hoping that you guys will join us for our worst banquet, which will be the first week in January.
First week in January, yes.
So, but thank you once again for everything. Kind of whatever. And this is Mike Sig, right? Yes, sir. All right. Okay. Yeah, for that. So, hey guys.
Take care. Okay. When you don't need a spousal signature, we touched on it earlier. Sole managed community property. This property under the sole name, control, and management of a married person other than homestead property. If you have an investor who is married but does not want his or her spouse to join in the transaction, As long as we have that affidavit designating their homestead, signed by the spouse, we would not need the spouse's signature. I talked about it earlier. If I'm an investor or if I'm a company, if I'm an LLC, a trust, a corporation, I don't need my spouse. If I'm an individual, solely just an individual, then yes. But if I'm an investor in investment property, then obviously no. But they will always sign that homestead affidavit. Always. When they don't join in the transaction. Divorce. When a party entitled to real property, holding either as separate or community property, is involved in a divorce proceeding, the decree must be carefully examined to determine as its effect on title to any real estate owned by either property. With the divorce pending, can the sellers sell their home, or do they need to wait? So I'm going to cover the first part first. When a party entitled to real property, carefully examine. When I asked or you asked your client for a divorce decree, I want the whole divorce. I want every page of the divorce. The one that talks about the kid's visitation and it has personal information. Because if you did not do a deed from your ex to you, I may need the actual divorce decree because I'm going to record it with the counselor. I'm going to talk about that too. But I need to carefully examine the divorce decree. Why? What if there's reimbursements to so forth because they put money into the separate property? What if something is owed to me and in the decree it says I'm owed 50,000? That's on page 13, but you only gave me page 14 when it says you're the owner of the property. Oh, well, you don't want to give me page 13 because it had me taking money away. I've had that situation happen. They did not want to give me the whole thing. And I was inquiring, well, why don't you want to give me the whole thing? I got to report it. If you don't give it to me, I'm going to order it from the courthouse. And they're going to charge me $300. So either you give me your copy or I just order it from the courthouse or we don't close. And they gave it to me and I'm like, oh, okay, it's because we had a $50,000 in there. So they excellent. With the divorce pending, can the sellers sell their home or do they need to wait? Do they need to wait or can they sell? They can sell? Everybody's on agree they can sell?
Yes.
Most spouses must execute the deed and the proceeds check will be made payable to both spouses. And that's all. But if you can, your husband and wife, you're going to sign as husband and wife. Your divorce isn't final, so you're husband and wife. The check is going to be made to John and Jane Doe. That's going to be made to both of you guys. Unless you instruct me otherwise. And we do it all the time. Separate checks. I want it 50-50, 60-40, 70-30, full. You're going to sign off on that. You know, the proceeds form like, oh, sign off. But yes, you can. You can do it while it's pending, before you do it out. Use of a power of attorney between them is not approved. Duh. That shouldn't even come up. We're getting a divorce. There's no way she can have a POA to sign on my behalf and vice versa. Conflict of interest. We will not approve that. Even if they're on good talking, speaking terms, we're not going to. Can one party purchase or take out a loan while the divorce is pending? I'm going through divorce. It's not final, but I want to buy a house. Can I?
No.
Saying yes. You're saying no. No.
Yes.
Then yes. If the home will be one of the parties' primary resident, the future ex-spouse will need to join in her homestead. Now, if I'm buying a separate house, an investment property, no. But if it's pending, if my divorce is pending, so I'm married.
Right.
If it's pending, I'm married. I can't go and buy a homestead. See that a lot. I'm going through divorce. So what am I doing? I'm getting everything ready. I'm paying off everything, and I want a house. So the realtor will confirm a new house for me. I want to get ready, and I want to close on the house. So when I get divorced and I have to move out, I don't have to see her anymore, and I'm going to go to my new house. You're not divorced yet. Unless you have a second house in Texas, you're moving to a homestead residence. Your future ex-wife still has to sign. A property purchased by one spouse prior to divorce could be awarded in the decree or deeded by the ex-spouse to the titled spouse. So such action will prevent problems when the property is subsequently conveyed. So we're going back to the beginning. On the property purchased by one spouse prior to divorce should, so a separate property, should be awarded to them in the decree. But again, it all comes down to what's been happening before. You can negotiate whatever you want. But you bought it separately, you do not use community funds, it should be awarded to you as your property. when you don't need a spouse's signature. Example, couple is getting a divorce and one wants to buy a new home during the divorce without the spouse's signature. It's possible, but we will ensure as long as there's a standard exception in place on the owner's policy. Except we won't close it if the purchase violates a court order. Let me go back to the second one. Exception means deletion from the policy. So going back to my example, I want to buy my house. I want to move into it. So when I leave her, I'm going straight to my home. Possible. I'm going to add the deletion in the policy. In other words, I'm going to place an exception in the commitment and says, if this ends up being your primary residence, if she's into the property, blah, 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 I'm going to protect my butt left and right. Because if she comes back into this, her homestead property, she's not going to sue me. She's going to sue you as the buyer. She can go after the lender if she wants. If it's a lender deal, probably not going to be. But it's going to be totally up to them. Lenders don't like exceptions on policies. Exceptions means not covered. Deletion means not covered. They don't like it. They like a clean policy. And of course, if it's a court order, we're not going to violate a court order. I know we're running a little over because Lynn started a little late, so I'm going to try to go back and go through a little quicker. We have 12 more slides. Real world situation. Example, a couple is getting a divorce. The decree is not yet final, and one wants to sell a property without the spouse's signature. Can we? And the reason why I'm going to fly through this is because we really talk about it. We will not ensure that. It doesn't matter if it's separate property, community, or joint managed community property, because the court decree has not determined the status of the property. Okay? This is not buying, this is selling. The last slide was about the buying. Possible with an exception. This one is they're getting a divorce and one wants to sell the property without the spouse. No. You're going to go into your husband, you're still there. Now, if the divorce becomes final the day before closing, we are not going to close until I see. The day of closing, an hour before closing, we are not going to close until I see the divorce. I want to make sure we're following its terms, and I want to make sure you're not owed something to the excess. Real world situation. For example, a couple getting a divorce and one wants to deed the homestead to the other to get a home equity loan without the spouse's signature. We will not insure that. Again, it goes back. Texas Constitution prohibits loans on homestead without the spouse's signature. Okay? Getting a divorce. You want to deed the homestead to the other to get a home equity. We will not insure it. It goes back to the Texas Constitution. Real world example. The divorce decree signed September 1st, 2021, and on September 10th, 2021, spouse who obtained title to residence wants to close on a home equity loan to fund the divorce settlement. Not a lot of people know it's coming up. We will not insure that. Well, why? The divorce decree was signed September 1st, 2021. 9 days later, they want to do a home equity loan. Policy by themselves for the divorce. A divorce is not final until 30 days after the decree is signed. So you can't just get divorced. I'm going to go buy my house now. I'm ready to go. Pump the brakes. You got to wait.
Wow.
And 30 days may not be 30 days. I'm going to show you the real world situation. There is no such thing as legal separation in Texas. A person is married until the day the divorce decree is signed. I'm separated. We've been separated for 30 years. I don't know where he's at. You're not divorced. He has to join me.
That's so weird. I'm so sorry. Because common law is effective the minute you live together and start divorcing. Oh, this is my husband, this is my wife, right? But on a separation, even if you've been separated for 30 years, you have no idea where they are. You can't be
That's true.
not separated.
That's true.
Interesting.
You have that
Well,
marriage, that legal binding marriage, and you can't just separate.
mhm.
So when is a divorce final? Is it once it's signed by the judge? Remember I talked about 30 days?
30 days.
The divorce decree is subject to appeal or modification for 30 days after it is signed, so it's not final. It should be 40 days. Because an appeal or motion for rehearing mailed within 30 days of the decree being signed and received by the court within 10 days of being mailed is considered timely filed. So technically 40. Learn something new every day. Real world situation. Couple is going to get a divorce and they want to deed property from one to the other prior to divorce in order to get the spouse out of title and so they can refinance. Don't be so. We get this request all the time, but if the property is characterized by marital status at the time it was received, how could this change? Deeding between spouses during marriage has no legal effect on it. So me and my wife were owners of the property. We own it 50-50. We can't just deed again for her. She has 50. I can't give mine. And that's where divorce or a divorce is in place. And the divorce decree states that part of the divorce, I need to sign a deed, which is a special one. Then okay, different situation. But just cause without a divorce in place, there's no legal effect on a deed between spouses. No proper determination of title. You get the quickie divorce, and the decree does not address ownership of separate real property. You're divorced. You bought multiple houses before you married, but the divorce does not mention your separate property. If you're past the time period for appeal and the decree is final, we're going to follow the inception of title rule and treat it as community property. You got a really bad divorce decree. It's 2 pages long, and it does not mention your separate property. So it's community. Get that divorce amended. You can get it amended. You have to do divorce court and have the judge amend it. World situations. Property awarded to one spouse in the decree, but there is only a street address. No real property property description, which is a legal description. It only mentions the address. Historically, we've turned these down and required either the court order to be clarified or amended by the judge or a special warranty deed from the ex. Now, if you have tried and failed to get a deed from the ex, we will look at the description and make a judgment call as to what the address is sufficient to avoid future confusion. Remember, keep in mind, title insurance is not based on addresses. So if the divorce decree says 123 Street, that does nothing for me. I need the legal description. Lot 1, Lot 2, NCB is a paragraph, legal description. Now, we'll take a look at if it doesn't have the actual legal description, and we'll take a look at the decree, we may be able to work with it. If it says 123 Street, also known as Lot 1, Lot 2, and then that's it, and it doesn't have a full legal description, we may be able to work with it. The underwriter call. So I'm not saying yes, but we may be able to do it. If it does not have a clear legal description, why does it need a clear legal description? Because as I mentioned before, I only get page 13, but you didn't give me, I only got page 14. I need the whole package. Why do I need the whole package? Because I'm going to report it with the county records. They're not going to take just page 14. They want the full package. They want the full document. County records, when you report a deed or mortgage or release lien, whatever it is, they go by legal description. Their index is filed by legal description. So if I have a divorce decree where it says, I owe you the property, you're awarding the property, that document that's transferring the interest to you, it's not a deed, it's a divorce decree. And it gets recorded with the county records like a deed one. And it's indexed by the legal description. It's not indexed by the address. It's not even once you reach. So that's why a legal description is always needed in a divorce decree. If it doesn't have the legal description, and it still says 123 Street, and underwriter is like, nope, I can't do it. This does not. Then you're gonna do the special warranty from the ex. They're gonna have to get involved. And I've done this before. We'll draw up the deed for them. They're gonna have to come in, they're gonna sign that special warranty because that divorce decree is junk. It does not have a legal description. I can't do anything with it. I can't record it. And if you don't want to amend it with the judge, then just come in and sign off on the deed, a special warranty. Parties can have the judge amend the decree to state the clear legal description of the property being awarded. Property awarded in the decree and spouse ordered to deliver deed, but no deed filed of record. These are just real world situations that we come across, and I talked about that earlier. The property was awarded to you. It was awarded to you via a deed, But there was no deed filed of record. We're gonna file the divorce. You see the deed of the divorce. Generally, we like to have that deed, but if we have a completely uncooperative spouse and the decree is specific enough, it does have the legal description, we can file a certified copy of the deed. Talked about that earlier. Okay, the decree is transferring the interest from me to you. It's just like a deed. I have to record it like a deed, so I can record that. It mentions a certified copy of the decree. The county record, the courthouse, they will not record copies. I don't know if you ever personally tried to record a document downtown. They do not record copies. They want the original document or certified copy of the decree. And not a lot of parties know that. Not a lot of agents know that. And not a lot of sellers going through divorce know that. But when you get divorced, you and the ex usually get certified copies of the decree. I need that. I'm going to record that with the county record. A divorce decree, a certified divorce decree, the very last page, it has a stamp from the court. That's what I need. So if somebody ever gives you a divorce decree, the title company tells you like, hey, ask your client for the certified copy of it. If they don't have it, I'm gonna order it from the courthouse and it's expensive, $200. But tell them to give me the certified copy of it and they give it to you, flip to the back of the page, stamp. I need to see a stamp on that very last page. It looks like a copy because technically it is a copy, but it's a certified copy. Have a stamp. It's a wet stamp from the court. I need that. If not, I'll order. And the customer needs to be comfortable with all of his or her personal information and the decree being made public. Remember, I reported it's a public record, it's just like a deed. So if it shows the kids stuff, visitations, all that, it's going to be made public. Common law marriage. Texas is one of 10 states that still recognize common law marriage. Texas Family Code Section 2.401B says a man and a woman are common law married if the man and the woman agree to be married, and after the agreement, they live together in this state as husband and wife, and they represented others that they were married. That's why I always go back. You play husband and wife, you're playing house, you're acting like husband and wife, you're common. The issue is not whether they are married, but whether they can claim to be common law married later. That's what I said.
Is there a time frame that they have to be?
There is. Right. And one day, basically, there is no time frame. One day. There is no minimum required time. For example, a couple live together for one day and be considered common law married if they agree to be married and hold themselves out of. There really is no time frame. Day one. It cannot exist if either party is married to another spouse, or if the parties are under the age of 18. An example, real world situation. Joe Smith arrives at the title company office to sign closing documents. Mark Johnson accompanies Joe to the office. Joe and Mark are wearing wedding bands, and Joe introduces Mark to the closer as my husband. The closer was unaware until now that Joe is married. Probably because in his marital status affidavit at the beginning, he put single, is it common law, right? Through some questioning, the closer discovered that Joe and Mark have been living together for 25 years, and they consider themselves as married and refer to each other as husbands. We are treating them as a married couple. Now he has to be involved. Now I need to run his name, and we're going to delay closing because he's just like us. And if he has liens, we're going to collect them. Prenup agreements. Prenuptial agreements setting aside homestead as separate property does not change the Texas Constitution requirements for the joining of the spouse to sell the homestead. Spouse's signature still required. Because prenup agreements are subject to so many fact-based differences, title companies will generally not insure title based on prenup agreement. Any questions? You guys are good? I know it's a lot of information.
Yeah, it is.
So that QR code is my email in case you guys just want to save it. Also, my cards are here. You can email me anytime, day or night, after hours, weekends, holidays. If something pops up later on down the line, and it doesn't have to be about marital rights, guys. I do a lot of other classes. Yeah, to board airship, survey, FIDO, everything. Let me know. You can have a situation that's going on right now. It's a common law situation, divorce situation, death. Just reach out to me, let me know. Again, also my cards are going to be on the table. They're down here. They'll come on the table for you guys. Any questions about any of that you just learned?
Let me ask you a question. So you said when they're going through a divorce and the husband is gonna, and it hasn't been finalized and the husband's gonna give
Thank you.
his interest to the wife, you said that they could do a special warranty deed,
If they're going through divorce.
right? Okay, but wouldn't they do like a quick, claim deed?
Can do quick claim deeds.
Okay,
Quick claim deeds or trash deeds organized by title.
because
So if you ever,
they were doing them, right?
I think a long time ago. So I used to be a title examiner and I used to pull up deeds from the early 1900s. Mid 1940s, 1950s. Back then, they would do quick claim deeds left and right.
Okay,
No,
they're not doing
we
it
did not recognize that at all.
at all,
Gotta be a warranty deed.
just a special warranty.
Gotta be a warranty deed or a special warranty deed if it's a divorce situation.
Okay.
So like a regular policy, it'll be just a warranty. General. So that is it, guys. Again, but she showed me some reason the QR code may not be working, but email's there. You guys have my cards. Please let me know. Also,